May I begin by introducing our first speaker this afternoon. John Lorn McDougall, despite my repeated requests, failed to provide me with a curriculum vitae, but in his case, that's less serious a problem than it would be with many other speakers, because his accomplishments have been so clear and so obvious that I can tell you about him simply from having practiced with him in recent years. John Lorn is a partner at Fraser and Beattie, where he's practiced since his call in 1968. He has a varied practice involving civil, commercial, and administrative litigation. Perhaps the case on which I got to know him best was the Morrison Inquiry, which you may recall when the trust companies were seized some 14 months ago. The minister in the Ontario government appointed a commissioner under the Loan and Trust Corporations Act to inquire into the status of the trust companies. And the minister appointed Fraser and Beattie as the solicitors for Morrison as the commissioner, and John Lorn McDougall was counsel to Jim Morrison. Having dealt with John Lorn in that inquiry, I came to know more about him than would ever be disclosed by a CV. He organized, conducted, and completed complicated hearings and reported to the minister within 8 months of the appointment, itself a record. He examined literally scores of witnesses on literally thousands of documents, day after day for months, and somehow did so fully prepared, oriented to the issues, and to great effect. Perhaps most importantly of all, he dealt with scores of lawyers, sometimes in very explosive circumstances, when feelings were running high. He did so with a civility, a patience, and a professionalism which was in the highest standards of our profession. And I presume to speak for all the other lawyers who were involved in that inquiry when I say that no matter what else was going on there, we always knew we were being treated very fairly. Recently, John Lorn has been counsel in a case in which leave has now been granted by the Supreme Court of Canada called Garry and the Queen, which puts into issue many of the precepts involving public interest privilege in cabinet documents. That afforded John Lorn an opportunity to read the cases in that area for the first time. He's now well acquainted with the principles. I look forward to his address. John Lorn McDougall. It's best on the lapel, I think.
Allan, thank you for that highly and overly flattering introduction. It was a pleasure to work with you and the others on the commission. It could have been a lot worse than it was. May I begin with a statement of the obvious in this topic of privilege in civil cases. A privilege is the right accorded to some to do something that let me start it all over again. A privilege is a right accorded to some to do something others are not permitted to do. And conversely, it is the right not to have to do something that others are required to do. In the legal context, a privilege is a right to withhold evidence from a court. Whenever such a right is claimed, there are two separate questions. Does the privilege exist? And if so, does it extend to the evidence that is sought to be adduced? The focus of this paper, in conformity with the theme of these lectures, is on the nature of privilege and the changes which have occurred in recent years. The frequently cited passage from Ex parte Fernandez is a convenient and useful starting point for any discussion of privilege. And the quotation is, "Every person in the kingdom, except the sovereign, may be called upon and is bound to give evidence to the best of his knowledge upon any question of fact material, and relevant to an issue tried in any of the Queen's courts, unless he can show some exception in his favor. And it's the exception, or otherwise known as a privilege, which deprives the court of evidence that has undergone reappraisal and revision in recent years. By way of introduction, I should say that any privilege is granted on public policy grounds, the justification being that it is in the public interest that the witness not be required to give evidence despite the possible effect upon the particular piece of litigation before the courts. The privilege, which is also sometimes called an immunity, is founded on the court's view of what is in the public interest, and in appropriate circumstances, it has the clear power to require evidence to be given despite any claim of privilege. Now, the most notable recent developments in the area of privilege have been in Crown privilege, otherwise known as public interest immunity, and solicitor and client privilege. And I've restricted this paper to those two topics. And I want to deal first, if I may, with solicitor-client privilege. And I'm going to narrow it even further. There are two different strands to what is usually referred to as solicitor-client privilege, and it's also called legal professional privilege. The first strand is the privilege attaching to communications, verbal or written, of a confidential character between a client and a legal advisor directly related to the seeking, formulating, or giving of legal advice. The second strand is the privilege attaching to the papers and materials created or obtained especially for the lawyer's brief for litigation, whether the litigation is existing or contemplating. As I say, I'm going to deal only with the first of those categories, which I will call solicitor-client privilege, although it's called by many names. The second strand, the work product, will be covered by Professor Sharpe in the next lecture. Solicitor-client privilege was initially tied to the litigious process in the sense that for privilege of any kind to obtain, litigation had to have been commenced or be in contemplation. But as long ago as 1833, in a case called Greenough and Gateskill, the scope of the privilege was expanded to include communications made to seek advice irrespective of whether litigation was pending or contemplated. That decision also contains the beginnings of the elements of the rule that we now practice with. And skipping from 1833, I go to 1969 in a case in the Exchequer Court of Canada, Susan Hosiery and the MNR, where the law as it has developed was reviewed and certain principles were laid down. The case dealt with the question whether a privilege attached to correspondence passing between the appellant's solicitors and the appellant's accountants, and it was in the absence of litigation. The President Jacket stated the modern rule of solicitor-client privilege and stated that the following four elements, have to be present if the privilege was to exist. There must be a communication, whether verbal or written. It must be of a confidential character. It must be between a solicitor and a client. And it must be directly related to the seeking, formulating, or giving of legal advice. Those four elements must be present, and if they are, the communication and all of the legal advisor's papers relating to that advice are subject to the privilege. And in the facts of that case, perhaps strangely, the accountant-lawyer communication was granted a privilege. Now, in the 15 years following Susan Hosiery, those four elements of the modern rule have been subjected to a judicial scrutiny. The result has been a trend toward the narrowing of the scope of the privilege, but at the same time, the privilege itself has undergone a judicial change, so that it is no longer just a rule of evidence, which it had been heretofore, a rule of evidence applied only at trial. I'm going to break those two trends down and deal with the nature of the rule and the judicial consideration of the various elements in recent days. Firstly, dealing with the nature of the rule. The claim to solicitor-client privilege commonly arises in two different circumstances. It's well recognized, of course, that the privilege may be raised in the context of a trial or the trial process as a basis for objection to a court receiving what would otherwise be admissible evidence. But it's now established as well that it's also possible to assert privilege to prevent disclosure of communications between yourself or solicitors and client prior to and in the absence of litigation. The first mature statement of the modern rule, which I've just stated, appeared in a case under the name of Director of Investigation and Research in Shell Canada Limited, which considered the application of Section 10 of the Combines Investigation Act. Shell Canada, the solicitor, Mr. McCaig, then solicitor, rejected the view that Section 10 authorized the director to examine and take away from the firm's premises documents that would be subject to solicitor-client privilege if they were to be tendered in court. And in the face of this assertion, instead of just taking the documents, the director applied to the court for an order to obtain permission to see the documents, thus raising the issue, in the absence of litigation, whether he would be entitled to the documents and that Shell would have to wait until a prosecution under the Act ensued. The court held that the fact-finding process granted to the director by Section 10 were not intended to undermine the scope of solicitor-client privilege. And Mr. Justice Thurlow, who gave one of the judgments for the court, was brief and to the point, and I quote, "It appears to me that the confidential character of such communications, whether oral or in writing, comes into existence at the time when the communications are made, as the right to protection for the confidence, commonly referred to as legal professional privilege, we're calling it solicitor-client privilege here, is not dependent on there being litigation in progress or even in contemplation at the time the communications takes place. It seems to me that the right to have the communications protected must also arise at that time and be capable of being asserted on any later occasion when the confidence may be in jeopardy at the hands of anyone purporting to exercise the authority of the law." The following case in Ontario, this time it was in re Borden Elliott and the Queen, which again involved a search warrant under the criminal code to search the offices of Borden Elliott, seeking documents which were sought as evidence in respect of a fraud committed by one of the firm, alleged fraud committed by one of the firm's clients. There was, of course, no suggestion that Borden Elliott was in any way implicated in the fraud, but the warrant covered not only the firm's trust account ledger, but also any correspondence or other documents relating to the entries in that ledger, a broad warrant indeed. The applicants argued that these documents were subject to solicitor-client privilege. Now, the first issue that had to be decided was whether the search warrant issued under the criminal code overrode the privilege. And the court, and it was Mr. Justice Southey giving the reasons, followed the Shell Canada case and applied the same reasoning to the search warrant, saying it did not override the solicitor-client privilege. He characterized a result that, to the contrary, as absurd. An absurd result if the privilege could only be asserted at a trial, leaving all the documents in the possession of the Crown until the Crown saw fit to lay a charge. In that same case, Mr. Justice Southey stated that the privilege does not properly apply to what are merely acts of a solicitor. And I quote, "It may be that entries in the applicant's trust account would be admissible and subject to seizure if they could be separated from all confidential communications from the client." Now, I'll come back to that when I deal with the privilege or lack thereof attaching to acts. In 1979, 4 years ago, the Supreme Court of Canada in Solsky and the Queen had its first opportunity of two to consider the application of the solicitor-client privilege in a pre-litigation context. That case concerned whether the privilege could be raised in the face of a commissioner's directive made pursuant to the authority of the Penitentiary Service Regulations, which permitted prison officials to open prisoners' mail, including correspondence, between a prisoner and his solicitor. Mr. Justice Dixon, who gave judgment for the court, made the following points. Firstly, that solicitor-client privilege is no longer regarded merely as a rule of evidence, which acts as a shield to prevent privileged material from being tendered in evidence in a courtroom. Secondly, that the case law, the Borden-Elliott case and the Shell Canada case, is characterized by the fact that there is an evidentiary connection between the request for the search warrant and their prospective use of the documents in litigation. And he went on to say that the privilege may therefore not yet be characterized as having developed into a rule of property bereft of an evidentiary basis. I should say that it was argued that the solicitor-client privilege was not just a rule of evidence, but it was likened to a rule of property. And finally, that the privilege can only be invoked and claimed document by document, and each document being required to meet all the criteria for the privilege. In formulating the evidentiary connection test, Mr. Justice Dixon applied the principle first suggested in Shell Canada, which I've read. The privilege does not need litigation to come into existence. It is created at the time the confidential communication is made and may be raised at any time thereafter. Having stated that evidentiary connection test, the court turned to the different issue which arises when the reasons for which disclosure of the documents are sought are such that the evidentiary connection test cannot be met. And Mr. Justice Dixon sought a means of protecting the confidentiality of the communication between solicitor and client in the absence of meeting this test. The court said in those circumstances it would balance the competing interests and reach a decision on the facts as to whether or not disclosure would be required. The interest to be balanced would be the importance of the solicitor-client relationship on the one hand and the public interest which would be served in any particular case on the other hand. Public interest in having disclosure in the documents. As you can see then, the result of the decision in Solsky was to broaden the scope of solicitor-client privilege. But if the evidentiary connection test is not satisfied, then you would only have the privilege if you can show that the privilege overweighs the other public interests. 2 years ago, in Descoteaux and Mirzowinski, the Supreme Court of Canada turned to the question again. And the issue in that case was whether a warrant obtained to search the premises of a legal aid bureau in order to examine an application form in which the applicant had allegedly reported a low income to be eligible for legal aid should be quashed. The appeal was dismissed on the ground that since it had been alleged in the information that communications with respect to the applicant's financial means were made with fraudulent purpose, the communications could not be privileged. But Mr. Justice Lamar, who gave judgment for the court, attempted at some length to explain Solsky. He distinguished between the two situations discussed by Dixon, that is, the application of the privilege prior to litigation when the evidentiary connection test is met, and the application of the balancing test to protect confidentiality of the relationship as much as possible when the evidentiary connection test is not satisfied. He gave them the names, the evidentiary rule and the substantive rule. I say with great respect that Mr. Justice Lamar's judgment is difficult to follow, at least I find it difficult to follow, but the fact that it was concurred in by Mr. Justice Dixon suggests that it is compatible with Solsky. And from the case, you can draw the following two propositions. First, that the rule of evidence, which may be traced as far back as the 16th century, is but the earliest manifestation of the more general right a person has to have communications with his legal advisor kept confidential. But the rule of evidence is that particular aspect of the right to confidentiality which underlies the solicitor-client privilege. It permits a claim, a privilege, to be made whenever disclosure is sought for the purpose of using the communication as evidence. The second arm or proposition is that the substantive rule is that aspect of the general right to confidentiality which which permits a court to construe very narrowly any statutory power to require disclosure of communications properly subject to the privilege, when disclosure is made or sought for a purpose other than the gathering of evidence. In drawing these two propositions from the case, it is clear that the court recognized that there is a general right to confidentiality, in this context in solicitor-client, and the characterization of the privilege which protects a solicitor-client communication in those terms as being merely one expression of a general right raises the issue whether the courts will hereafter find it appropriate to determine that other confidential relationships should also be protected with privilege. In my submission, the introduction of the balancing of interest concept in testing any fact situation where there's a confidential relationship means that there's no logical impediment to courts granting protection to other confidential relationships in appropriate factual circumstances. Now, completely apart from the consideration of the courts of the nature of the rule is the refinement, judicial refinement of the criteria for the application of the rule. And several of these criteria have been recently considered by the courts. One of them arose from the Morrison Inquiry and the investigation of the affairs of Graymac, which Allan alluded to. That case is Re Ontario Securities Commission and Graymac Credit. The divisional court reported last year. Mr. Justice Southey, the same judge who had dealt with the Borden and Elliott case, gave judgment for the court. And there are 4 or 5 elements of that case which are worthy of consideration because they are, in my view, an indicator of where the courts are likely to go when considering solicitor-client privilege in future. The first is the distinction between communications, which are privileged, and acts. And Mr. Justice Southey stated in the course of his reasons, evidence as to whether a solicitor holds or has paid or received money on behalf of a client is evidence of an act or transaction, whereas the privilege only attaches to communications. And further, the fact that a client is paid to and received from or left with a solicitor a sum of money involved in a transaction is not a matter as to which the client himself could claim the privilege, because it is not a communication at all. It is an act. In the context of that case, Morrison had asked for the divisional court's direction as to whether solicitor-client privilege had precluded a solicitor from answering questions which I had put concerning the movement of funds in and out of his trust account. The solicitor quite properly put the issue before the court and took no position, but felt that until the court ruled that he was free, he could not answer the question. He subsequently did because the court found there to be no privilege. That statement that there is no privilege attaching to an act is not a new statement of law. It's a principle that you can find as far back as the 19th century English cases. But the problem the courts in future will face is to define exactly what an act is and to separate it from the confidential communication. Justice Southey referred to that problem in Borden and Elliott and again in the Securities Commission. But as is obvious, the task of separating acts from communications lay with the special examiner. And so we do not yet have an instance where the court has been prepared to attempt the separation. If I may suggest it, if the word act is given a broad meaning, the result could be a very significant narrowing of what today is believed to be covered by solicitor-client privilege. And similar to the distinction between communications and acts is the distinction between communication and facts. The rule is that facts are not subject to the privilege. And even though the facts may be contained in a privileged communication, if you examine somebody and ask them for the facts, they're not entitled, in my submission, to say, oh, well, I got those facts in a privileged communication. I say that, but I refer you to last week's DLRs, a decision of the British Columbia Court of Appeal in Dusick and Newton, where the exact opposite view was taken, that the privilege attached to facts which were contained in a privileged communication. That's in direct conflict with the Susan Hosiery case, and all I can say is that it will be resolved, hopefully, by another court. Another issue that arose in the Securities Commission case was the question of the privilege attaching to the identity of the client. Southey held that the identity of the client is not the subject of professional confidence. It turns out that that's not new law either, but it was certainly the position taken by a number of solicitors in the Morrison Inquiry. Mr. Justice Southey held further that a solicitor cannot withhold as privilege the name of the client on whose behalf he receives, pays, or holds money, which, again, is old law, but restated in the modern context. And finally, on this section of the elements of the solicitor-client privilege, and in the context of the Ontario Securities Commission case, may I deal with the claim of privilege by employed or colloquially known as in-house solicitors. The classic statement of modern law on solicitor-client privilege on the position of employed solicitors is in Alfred Crompton and the Commissioners of Customs and Excise, where Lord Denning said that they are regarded by the law as in every respect in the same position as those who practice on their own account. The only difference is that they act for one client only. They must respect the same confidence, and they and their clients have the same privileges. But he later says in the same judgment, it does sometimes happen that such a legal advisor does work for his employer in another capacity, perhaps of an executive nature. Their communications in that capacity would not be the subject of legal professional privilege, solicitor-client privilege. So the legal advisor must be scrupulous to make the distinction of the two capacities in which he is acting. And the importance of taking such care to protect the privilege was underscored in the Ontario Securities case. Mr. Justice Southey cited the passages which I've just read and relied on another case in British Columbia, and then restated the rule, which seems to narrow the principle even further. The president of a company, who is also a solicitor, cannot assert the solicitor and client privilege in respect of information acquired by him in the performance of duties that can be, and usually are, performed by an employee or agent of the company who is not a solicitor. Now, it can be argued that if a solicitor received confidential information in a communication made to him in his capacity as a solicitor, the communication will not be privileged if he could have equally received the information in his capacity as an officer of the corporation. It may well be that Mr. Justice Southey's statement can be restricted to the peculiar facts of the case, but if it's taken to have a wider application, the result will be, in my view, that the employed solicitor, who is also an officer of his employer, will be under the double onus of demonstrating that a particular communication was made to him in his capacity as a solicitor, and that such a communication could not have equally been made to him as an officer of the corporation. By way of summing up on this section, may I say this, that there are the two trends which I've identified. They appear to be separate, but in my judgment, they're interrelated. First, it's apparent that solicitor-client privilege has been given a broader application by Canadian courts in recent years, and Mr. Justice Dixon expressly recognized this fact in Solsky. Secondly, there's a discernible trend to narrowing the scope of the claim. And the most recent example, of course, is the Ontario Securities Commission case. On one hand, the effect of affirming that solicitor-client privilege is not merely a rule of evidence has allowed courts to establish it as a right to protection from disclosure, whether or not litigation is pending. The courts in future will no doubt establish criteria for the balancing of competing interests where the privilege is claimed, and in the absence of the evidentiary connection test being met, and no doubt they'll do it on somewhat the same way as they've established or attempted to establish the criteria when a claim for Crown privilege is made. And On the other hand, though, it is to be expected that the courts will be a good deal more restrictive about what communications are granted the protection of solicitor-client privilege. The Supreme Court of Canada has said that privilege only arises where legal advice is sought from a professional legal advisor in that capacity and where the communication is intended to be confidential. All the elements must be present. These criteria aren't new, but there's a renewed emphasis today on the manner of their application, and certain types of information created out of the solicitor-client relationship have already been held to be outside the privilege. And it's not unreasonable at all to expect that others will be in the future. May I turn to the second arm of this talk, and that is Crown privilege, public interest immunity. And the title that Allan gave this talk, he called it public interest privilege. That's combining the two names, but they all mean the same thing. It had been thought for many, many years that the Crown had an unquestioned right to hold documents from production in civil cases. That right was considered to be an absolute one, and if a court was told, by affidavit, certificate, or otherwise, that it was the Crown's view that disclosure of the documents in question would be injurious to the public interest, the court would not require production, even if specific grounds for the claim were not forthcoming. All the Crown was required to do was make the court aware that disclosure would, in the opinion of the minister, be injurious to that interest, the public interest. But even in the beginning of Crown privilege, the privilege was not absolute in the sense that all documents in the Crown's possession were automatically privileged. The people claiming the right to withhold from production, even in the earliest of times, had to make the requisite assertion that it would be contrary to the public interest. And this suggests that even then, even in the early times, the emphasis was on the contents of the documents and not just the class of documents into which they fell. It appears, however, that where matters of foreign affairs, war, were concerned, there was no question documents would not be produced as long as they could be certified to fall into these classes. And even today, there are very few who would doubt the correctness of that result. The problem arises, though, with documents that are not so obvious on their face as deserving of the immunity. Robinson and the state of South Australia, which was decided in the 30s, was until very recently a forgotten decision. Nevertheless, it's highly important today as the case that first attempted to define the circumstances in which the Crown would be required to produce documents despite a claim of Crown privilege. That case was decided by the Judicial Committee of the Privy Council on special leave from an order dismissing an application for the inspection of documents. Lord Blainsborough gave judgment for the board. He allowed the appeal and directed that the Supreme Court of Australia exercise its power to inspect the documents in question to determine whether production would be prejudicial or detrimental to the public welfare in any justifiable sense. A little bit on the facts. The Robinson case involved a state marketing scheme established by the state of South Australia in which all the growers of wheat in that area were required to give the crop to the government for sale by it. Unfortunately for the growers, while the government had the wheat, the mice and water got at it, and they suffered a diminishment in their returns. The growers sued, alleging negligence by the government, and asked for production of all documents in the all documents in the possession of the state bearing on the custody of the wheat. The state refused and said it would be contrary to the public interest and gave no specifics. The board, the JCPC, accepted that state documents, and that's in quotes, were frequently absolutely privileged, but then went on to find that different considerations applied to documents relating to the trading, commercial, or contractual activities of a state. The privilege, the board found, was a narrow one and most sparingly to be exercised. The concern is for the public interest, and the rule is to be applied no further than the attainment of that object requires. And Lord Blainsborough then went on to identify the interests which are to be balanced by the court to determine if inspection is to be made. And this was the beginning of the weighing of contrary interests, a concept which has been developed and refined in the more recent jurisprudence. And I'm quoting, "Particularly it must be remembered in this connection that the fact that production of the documents might in the particular litigation prejudice the Crown's own case or assist the other side is no such plain overriding principle of public interest as to justify any claim of privilege. The zealous champion of Crown rights may frequently be tempted to take the opposite view, particularly in cases where the claim against the Crown seems to him to be harsh or unfair, but such an opposite view is without justification. In truth, the fact the documents, if produced, might have any such effect on the fortunes of the litigation is of itself a compelling reason for the production, only to be overborne by the gravest considerations of state policy or security." Now that's the late 30s. The board in Robinson had accepted that some Crown documents were absolutely privileged, but didn't specify what type they were, nor did they explain what they meant by the adverb absolutely. But the board is clear that it thought it could, if the interest of justice required it, inspect any document to see if the subject matter justified the Crown's claim. However, in Duncan and Cammell Laird, the House of Lords specifically rejected that proposition. And the speech of Viscount Simon, in which the 6 other law lords concurred, is the post-war starting point for an examination of the development of the law of privilege. It's the low point from the outsider's point of view. And it should also be noted, and this is perhaps the source of the confusion, that it was Duncan and Cammell Laird that the Lord Chancellor cast doubt on the use of the term Crown privilege, and he suggested that on his analysis the privilege could not be waived, and therefore it was more properly termed an immunity, a public interest immunity. And that term has passed into common usage, except that here in Ontario the Court of Appeal has suggested that both terms are wrong and that it would be better categorized or characterized as a claim for protection. Shortly put, the House of Lords in Cammell Laird held that a ministerial objection taken in proper form was conclusive. The court could not test the claim, nor could it require specifics as to why the public interest would be endangered by production. As long as the objection indicated that the minister had considered the documents and formed a conclusion, the court would go no further. The House paid lip service to the court being master of the process, but in fact, nothing was left for it to decide. If Duncan is the low point in this area of the law in terms of the availability of Crown documents, it is at least arguable that here in Canada that Duncan and Cammell Laird never became part of our law. Certainly our Court of Appeal has suggested as much. In Regina and Snyder, the Supreme Court of Canada distinguished the Duncan case on the basis that it dealt with civil proceedings, and it was there concerned with a prosecution under the criminal code. The court held that a witness was compellable and would be required to produce Crown documents, and this is the test, unless special facts or circumstances appearing on the minister's affidavit make it clear that there might be prejudice to the public interest in the disclosure, but only to the extent of the document or documents within the special facts or circumstances. If Duncan wasn't the law of Canada in civil cases, there are a number of open questions. The first had to do with the objections to production based on the contents of the document, and those based on the class. As I noted, the JCPC and Robinson indicated in passing that some documents were absolutely privileged. Was this a class of document, such as cabinet minutes, or documents whose contents dealt with national defense, foreign affairs, or high state policy, or both? And if the court wasn't bound by the ministerial objection, what interests were to be weighed to decide whether the documents should be produced and using what criteria. These matters fell to be determined in a line of cases which started with Conway and Rimmer, and it's perhaps fortunate that Conway and Rimmer dealt with very pedestrian facts. The former police constable sued his superintendent and sought production of 4 reports that the superintendent had made about them, and the Crown objected solely on the grounds that the reports fell into a class of documents, the production of which would be injurious to the public interest. Production was ordered. The law lords, by various means, overruled Duncan and held that the minister's objection was not inviolate and reaffirmed the earlier principles in Robinson. As the House of Lords was dealing with low-level reports, it was not required to consider higher-level documents, such as cabinet minutes, but it is apparent from several of the speeches that they regarded such documents as being immune from production merely because of the class they fell into. A number of examples were given of high-level documents, but no line was drawn. And it should be stated as well that the argument for non-production, which wasn't successful in Conway and Rimmer, was based on the public interest in ensuring candor in communications within the government. The House of Lords in Conway and Rimmer rejected that as a basis for a claim for immunity. And Lord Reid summed up the competing interests which had to be weighed by a court as follows, and these are the interests that are still regarded as the ones the court have to consider. It is universally recognized here that there are 2 kinds of public interest which may clash. There is the public interest that a harm shall not be done to the nation or certain public servants by disclosure of certain documents, and there is the public interest that the administration of justice shall not be frustrated by the withholding of documents which must be produced if justice is to be done. Conway and Rimmer, as I said, left open the question of whether there was any class of documents to which a court would give absolute immunity. When the House of Lords came to examine higher-level documents in Burma Oil in 1979, and it's Burma Oil and the Bank of England, and Air Canada and the Secretary of State for Trade last year, yes, the test became a little more restrictive. But before I turn to the Burma case, I should like to make this point. It's important to keep in mind the difference between the production of documents in England and the Canadian jurisdictions. And this difference may, and I emphasize may, explain the divergence between the Supreme Court of Canada and the House of Lords. Under the English rules, no order for inspection of documents will be made unless a court is satisfied that such an order is, and I quote the words of the rule, necessary for fairly disposing of the cause or matter or for saving costs. And in our jurisdictions, and the jurisdictions which give rise to the recent cases in Canada, the rules for production are quite different. If the documents contain material relevant to the issues in controversy, they must be produced. And I don't think the new rules will change that. In the English cases, particularly Burma and Air Canada, the courts were concerned with the rule which puts the onus on the party seeking production to demonstrate that the documents are necessary to fairly dispose of the matter. And in the Burma case, it was on that onus that they determined after inspection, which the majority of the Lords did, not to produce the documents. But the Burma case is significant for us because it established for the first time that there's no class of document that will never be ordered to be produced no matter what the circumstances. The decision whether or not to inspect or order production turns on the nature of the subject matter, the persons who dealt with it, and the manner in which they did so. And Lord Keith felt that in extreme cases, even the most sensitive documents could be ordered to be produced. And he referred to Sankey and Whitlam in Australia and Nixon in the USA. Both cases involved allegations of malfeasance on the part of the chief executive, and in both cases, high-level documents were ordered to be produced. In Burma, Lord Keith rejected the candor argument for the basis for refusing production, but accepted the suggestion made in Conway and Rimmer that the true basis for refusal was to prevent captious or ill-formed criticism, the work of government being hard enough without having to endure the gaze of those ready to criticize without adequate knowledge. Let me turn to this decade. In the 1980s, we've seen the House of Lords retreat from Conway and Rimmer, and the Supreme Court of Canada move forward from it to hold that relevance is all that need be shown to require a court to inspect the documents in issue. In the same period, courts in New Zealand and Australia have followed Burma and ordered production of high-level documents. However, here in Ontario, the Court of Appeal has taken a more conservative view. In Smerchansky and Lewis, which was a criminal case, the court reviewed Duncan and Conway and Rimmer and acknowledged the trend toward restricting the class privilege claim. But the court also stated that there were certain classes of documents, including those relating to cabinet proceedings, the conduct of foreign affairs, national defense and security, and the language I'm quoting, which by their very nature are generally acknowledged to be privileged. The BC Court of Appeal, in a case 2 years ago, Gloucester Properties and the Queen, fixed on that language of Mr. Justice Blair and Smerchansky. At issue in that case was the status of cabinet minutes and cabinet discussions. The court was asked whether the evidence of such a nature, by virtue of its class, was absolutely privileged, or whether the claim for immunity only prevailed when it was demonstrably in the public interest. After a thorough review of the English and Canadian authorities, Chief Justice Nemitz, who spoke for the court, held that the latter statement correctly expressed the law of Ontario. And he stated that the trend toward finding that no class of documents was absolutely privileged had not been followed in Ontario, Saskatchewan, or Alberta. And he was even more specific. He referred to the Smerchansky decision and noted that Mr. Justice Blair had not referred to the more recent cases. It should be stated, though, that Mr. Justice Blair did not say that the classes of documents he referred to were absolutely privileged, in the sense that they could never be produced. The statement was an obiter dictum, and it is unclear exactly what was meant by the court. The Court of Appeal, as Allan mentioned, had returned to the question last year, but in the interval, the Supreme Court of Canada spoke in Smallwood and Sparling. Smallwood is the Smallwood, a former Premier of Newfoundland, and he claimed that he could not give evidence with respect to matters involving proceedings in Cabinet. He claimed the immunity from giving evidence before a member of the Restricted Trade Practice Commission on the grounds of Crown privilege. As well, he claimed that his oath of office and the doctrine of cabinet secrecy prevented him giving evidence. And Madam Justice Wilson, again speaking for the court, rejected the latter two grounds and then reviewed the existing law with respect to Crown privilege. After noting that Conway and Rimmer suggested that cabinet minutes could not be produced until they were only of historical interest, she turned to Burma and summarized the result of that decision in the following terms. It was held that when a claim of privilege is made in respect of documents which are prima facie relevant to the issues before the court must review the documents in order to balance the competing interests. And she said, the Burma decision that the documents should not be disclosed was taken after the documents had been examined and seems to have been based on their finding that the documents weren't relevant to the issue between Burma and the bank. In short, the Supreme Court of Canada has held that relevance is the threshold. If the documents are prima facie relevant, the court is obliged to inspect and to balance the competing interests. That seemed to settle the law until Garry and the Queen. In that case, a subpoena was delivered requiring the Secretary of the Cabinet to attend at a trial and bring with him a number of high-level documents. The Court of Appeal upheld the lower courts, which had refused to require production, but did so for very different reasons and after a very thorough review of the law. Mr. Justice Thorson, who gave judgment for the court, held that there were no documents which were absolutely privileged, that were immune from production. but he didn't accept that relevance was all that had to be shown, and he suggested that Madam Justice Wilson may have misstated the basis of the Smallwood and Sparling case. He imposed on the party a three-part test which imposes a very heavy onus on an applicant to even get the court to inspect the documents. One of the elements is that you have to persuade the court that that you can't prove the facts sought to be proved by any other means. So we have this apparent conflict between Garry on the one hand and Smallwood on the other. What's the future? In Regina and Snyder, the Supreme Court had said special circumstances must be shown by the Crown. In Smallwood, the court established that the onus is on an applicant to show only prima facie relevance. And the Supreme Court of Canada seems to have left open the issue of whether the claim by the Crown of special circumstances could ever be so strong that it would refuse to inspect the documents. Garry, on the other hand, places the onus firmly on the party seeking production to do a good deal more than simply show relevance. If the Garry requirements are to be applied as they are written, it will be the exceptional case in which the Crown will be obliged to make production. There's a clear, in my submission, clear philosophic difference underlying the two decisions, and on the one hand, the Court of Appeal thinking that immunity is necessary, a high level of immunity is necessary for the proper working of government, the Supreme Court of Canada seeming to say that relevance is all that need be shown for inspection. After I was asked to do this lecture, the client asked me to apply for leave in carrying the Queen. Leave was granted, so it may be that some of the issues that I've alluded to will be dealt with in that decision, and the law will be straightened out one way or the other. And so 15 years ago, the inviolate right of the Crown to claim privilege was set aside, and the courts have attempted to replace it with a workable system. It's not yet apparent that they have succeeded. But the last several years has seen an expiry of an absolute immunity. What we don't have yet is a logical basis for giving high-level documents greater protection, which in my judgment they need, than the more mundane documents. And the issue is of more than passing interest to us as Canadians because, as far as I can see, we're burdened or blessed with more cabinets per capita than most of the Western world. Thank you, ladies and gentlemen.
Program. It's quite a difficult task to do justice to a 9-page, closely typed CV, but I'll do my best and try to highlight Professor Sharpe's curriculum vitae. Professor Sharpe received his first law degree from the University of Toronto and then went on to do a DPhil, a Doctor of Philosophy, and received that degree from the University of Oxford in the early 70s. He's been a professor at the University of Toronto since 1976, and last year achieved the distinguished rank of full professor. Prior to taking up teaching, he practiced in this jurisdiction for a number of years with the law firm of McDougall Potts. His areas of expertise are the area of civil procedure, remedies. He has taught criminal law and recently undertook a course in civil liberties. He's the author of a number of significant texts, a book on the law of habeas corpus, which was first published in 1976, and Professor Sharpe is working on a second edition of that text. He is perhaps known to you more from a recent book that's been published called Injunctions and Specific Performance, published last year, and it's a very, very readable and very useful text on those two remedies. He's written a number of articles. He has an extensive list of articles and notes and comments. And speaking on a personal note, I've had the privilege, and there's no pun intended, of editing 2 of those articles, and it was a very, very easy task indeed. He brings to bear to his topic today the various perspectives of his career, and he will be discussing claiming privilege in the discovery process.